In 2018, attorney Jeffrey Mark Siskine ran for Florida Attorney General. Now he is facing disbarment by the Florida Supreme Court because he allegedly stole over $2 million from just two of his clients. Let's have a look. So attorney Siskine hasn't gone before the Florida Supreme Court yet, but the referee in his case has come out with their report. This report went directly to the Florida Supreme Court, and as we will see, it says that the respondent, Mr. Siskine, engaged in schemes to defraud two clients. His unethical and fraudulent actions resulted in financial losses to his clients of more than $2 million. It goes on to lay out the facts in two separate counts. The first count, it says that Christopher George was in federal prison in 2013. On or about December 2013, George had received a refund from the IRS in the amount of a little over $2 million. George hired respondent, Mr. Siskine, on or about the end of 2013 as an attorney to protect and safeguard the bulk of the $2 million tax refund, among other things, during his incarceration. George's $2 million was transferred into Wells Fargo Bank trust account ending in 9721. That's Mr. Siskine's trust account, was primarily disbursed by Mr. Siskine through three transactions totaling over $1.9 million. The first was $100,000 to Sovereign Gaming and Entertainment LLC. The second was for $1.8 million, also to Sovereign. And the third is $70,000 to the Ocean Reef Club. There were a multitude of other transactions and two reimbursement checks totaling $10,000 that went to the client's wife, Diana George. The only authorized payments made from George's IRS refund were payments totaling approximately $100,000. So $1.97 million was deducted from the trust account and only $100,000 was authorized. To date, George has not received the bulk of the return of George's IRS refund money that he entrusted to respondent for protection and safekeeping. Sovereign, the recipient of $1.9 million of George's tax refund, was wholly owned by respondent's father and disbarred Maryland attorney William Siskine. So apparently the apple doesn't fall too far from the tree. Respondent and Bruce Irwin Lowe were the sole signatories on Sovereign's bank account. The $1.9 million that respondent dispersed to his father's company, the account number ending in 1472, was then emptied by respondent primarily through 14 transactions totaling $1.8 million and a multitude of other transactions. And then the referee goes on to say what those transactions were. The bank balance in Sovereign's account was overdrawn in the amount of $200 as of April 9th, 2014. Now remember, this guy ran for Attorney General of the state of Florida in 2018 after all this occurred. On February 3rd, 2014, a wire transfer from Sovereign in the amount of $1.1 million was deposited as a book transfer credit into Florida Association of Community Banks and Credit Unions account ending in 6890 at JP Morgan Chase. A bank signature card was obtained for that account. It substantiated that respondent, Jeffrey Siskine, was the only authorized signer of that account. So he transferred $1.9 million of his client's money from his trust account into his father's business. He then transferred the money, $1.1 million of that from his father's business into his own bank account. The bank balance in Florida Association of Community Bank and Credit Unions account was $6.07 as of May 27th, 2014. Basically, the referee and the attorneys representing the Florida bar are going through the financial transactions to show that this Jeffrey Siskine has made all of this money disappear at this point. There's essentially no way for his client to get back this $2 million that was lost. So they then go through how the Florida bar rules were violated regarding another count. This is the second client in this 2-client list, and it is regarding one Frederick Volqueen. Volqueen requested that respondent represent him concerning a sale of commercial real property identified as Northwood Properties. After the contract to sell the Northwood Properties was signed, respondent suggested and advised that Volqueen should enter into a 1031 exchange as a way to defer capital gains tax. Respondent provided Volqueen with a 1031 exchange assignment agreement, which respondent had drafted. The assignment agreement provided that Chance and Anthem, a limited liability company, would serve as an intermediary to facilitate the 1031 exchange. Chance and Anthem, though, was actually owned by Mr. Siskind. The settlement statement for the closing of the Northwood Properties reflects a sales price of $1.375 million, with all proceeds going to Chance and Anthem, this attorney's company. Several transactions totaling approximately $525,000 not benefiting Volqueen were made from the money that was supposed to be going towards this 1031 exchange. A like-kind exchange, the 1031 exchange, never took place. To date, Volqueen has not received a return of all funds entrusted to respondent for the like-kind exchange. So essentially what they're saying is there's somewhere in the ballpark of $500,000 here that's just missing. It's just gone. After they go through both of these counts, the referee here then goes through the basis for the findings of fact as to each count. And there are a few points here that I want to point out to you. Respondent provided Diana George with a written breakdown of how George's $1.9 million was spent, which respondent labeled as a total outlay. So here's the breakdown. So he tells this guy that he's got gold holdings, 815 shares of gold holdings, which were purchased at $1,228.20 for a total of about $1 million that his client has in gold. He's also got $300,000 invested in Bitcoin, $200,000 invested in Litecoins, and then there were several disbursements that were made for expenses. But we've got $1.5 million here that is supposedly invested in gold, Bitcoin, and Litecoin. During the course of this matter, respondent claimed that in reality, George willingly, wholeheartedly, and without any security lent his $2 million to Sovereign Gaming and Entertainment. So we have the respondent documents to his client saying, I invested your money in these places. We have respondent's bank accounts showing none of this money was invested in these places. And now we have the attorney saying that this was actually all a loan from the client to his dad's company. So the attorney's theories on this case are all over the place. The possible things that could have happened here, he's all over the place with these. But the bank accounts reflect that, well, he took the money. Respondent provided copies of 2 promissory notes regarding this alleged loan. He says that they were initialed by George in the attorney's presence in the Atlanta Penitentiary at the end of January 2014 as a basis for the loan. So that's what he says. End of January 2014, I went up to Atlanta. I got these documents initialed just to make sure we had everything on the up and up. But the referee notes both of these promissory notes contain what purports to be the signature of William Siskind, respondent's father. Respondent admitted that his father did not sign either note, but instead his father's friend and caretaker, Willie Russell, probably signed his name. Respondent claimed that due to his father's childhood polio, he could not sign these documents. He gave no explanation why, if another person signed for his father, that was not indicated. Why wasn't it signed Willie Russell for William Siskind? But That was explained by the bar's cross-examination. During the bar's cross-examination of respondent, the bar presented respondent with several mortgage documents from 2016, 2 years later, where respondent had witnessed his father's signature. Some 3 years after respondent claimed that his father was unable to sign the promissory notes that he claimed were for George. So he tells the court under oath. He tells this referee under oath, look, this was all for a loan. I went up to Atlanta. I got this guy's initials on it. My dad's caretaker signed these things because he has polio and that prevents him from signing anything. Yet 3 years later, his dad's signing documents elsewhere. So obviously what this attorney, Mr. Siskine, is saying is a lie. Additionally, the referee points out, look, you went all the way up to Atlanta to get initials on a promissory note. Why didn't you have him sign his full name? Well, the client says, well, that's because I didn't even initial these. I've never seen these before in my life. Upon review and consideration of the testimony and evidence on this point, I specifically find that Mr. George never initialed either promissory note and never agreed to lend his $2 million to Sovereign. The first promissory note in the amount of $200,000 was dated December 24th, 2013. That is a false date and obviously selected with historically revisionist intent by respondent. Instead, respondent was in South Florida on December 24th, 2013, working with Diana George, his client's wife, to ensure that George's funds were properly wired to his trust account. Therefore, based on common sense and a basic understanding of the laws of physics, respondent could not be both in Atlanta, securing George's initials on an alleged promissory note, while at the same time be in South Florida, working to have George's funds wired into his trust account. Respondent further stated that he was actually representing Sovereign and obtaining George's initials on these notes. So, just so that you understand, this is Siskind, the attorney for George, his client. George has now sued him because he apparently absconded with all this money. In defense of himself, this attorney is saying, well, yeah, I was George's attorney, but in this particular matter, I was representing my dad's company. And no, I didn't tell him that this was my dad's company. And I didn't tell George that I was actually representing Sovereign, my dad's company, in getting your initials on these documents for this unsecured loan that you allegedly are giving to my father's company. And not only that, but I also represent my dad from time to time. So he's representing 3 different people in this transaction, but he didn't tell anyone that he has a conflict here. Not to mention the fact that he's on the bank accounts for his father's company. So the conflict of interest is palpable here. So with all of that, the referee makes these recommendations. I recommend that respondent be found guilty of misconduct justifying disciplinary measures and that he be disciplined by disbarment and payment of the Florida bar's costs in these proceedings. There's an aggravating factor here. On December 8th, 2023, during the second day of the final hearing, respondent testified under oath as follows. Because I believe that, first of all, I've done a lot of investment type transactions with clients in the cannabis area. Part of his story was that some of these monies were investments in cannabis on behalf of his client, George. With clients in the cannabis area, in the Native American gaming casino area, and other investments, and I've never had a client turn on me and sue me and come up with a complete game plan for attacking my credibility, my honesty, and I guess also my competence like this. This has never happened. I've practiced law for 25 years now, and for 20 years before this. The referee notes that during cross-examination by the bar and when confronted with civil complaints filed by two former clients, not the two that are here, two different ones, Sarah Dozier and Belmar Wins, who were suing respondent with claims of dishonesty, fraud, and incompetence, respondent claimed to have forgotten about those cases. So an aggravating factor is you're perjuring yourself. You know that you've been sued by clients before regarding your fraud, and yet you're telling this panel that you have never been accused of anything like this in your 25-year legal history. So I say all that, I bring all this to light to say this. This guy is a member of country clubs. He's a guy that you might see at the Trump, because some of the payments that were made from Mr. George's money were made to Trump resorts. He ran for attorney general. He's apparently a pretty well-known attorney and probably moves in circles where you would think he's not going to be moving in these circles if he's not an upstanding citizen, if he's not an honest guy, if he isn't doing well for his clients, on behalf of his clients. And yet, the referee seems to think that Mr. Siskind absconded with over $2 million of just two clients' money, and there are two other clients who are suing him. At least two other clients who are suing him. So I say all that to say this. One, the Florida bar should be disbarring this guy. And two, be careful who you choose to represent you in anything, because you never know what these people are doing with your money. If you are depositing money for people, if you're giving them retainers or giving them money to put in a trust account, you need to see all of their insurance paperwork and all of their disciplinary history before you give them that money, because not all attorneys are here looking out for your best interest. My name is Nathan Saunders, and this is The Legal Good.